Hi, my name is Dennis Doss. I'm with the law firm Doss Law. Welcome to our presentation today entitled The Rebirth of Owner-Occupied Private Money Lending Post-Dodd-Frank. You know, I'm really excited about this topic. For the first time, I believe in many years, I see a renaissance or a resurgence of the ability to make owner-occupied loans in a manner that was probably unsafe before the passage of Dodd-Frank. And frankly, the topic kind of surprised me as I dug more deeply into these regulations, because there's been a lot of, I guess for lack of a better word, fear-mongering about Dodd-Frank and its impact on the lending industry. And in my study of the impact of Dodd-Frank on particularly what we're going to call small creditors, lenders like yourself, it's actually much better and much safer to make owner-occupied loans than it has been since the passage of Section 32.
The title of our webcast is The Rebirth of Owner-Occupied Private Money Lending Post-Dodd-Frank. The purpose of this webinar is to give you an overview of private money residential lending after the January changes in Dodd-Frank that will affect all of consumer lending. To view this webcast full screen, you'll notice in the lower right-hand corner of a small frame that you're looking at, a place where you can expand and explode the screen to a larger frame. That'll make it a little easier to see some of the materials I'm going to cover with you today. Some housekeeping matters. This webcast is the copyrighted property of Doss Law and may not be reproduced in whole or in part without the written permission of Doss Law. Please do not share this webcast with others outside of your organization. The information in this webcast is educational material. No legal advice is intended. Consult a qualified lawyer before implementing anything you see or learn in this webcast. If you haven't printed the program materials or at least looked at them, I strongly urge you to pause this webcast and do so now. There's a note about the scope of this webinar. This webinar focuses solely on closed-end private money real estate loans, secure loans by small creditors, which you will learn about later. Adjustable rate mortgages, HELOCs, prime loans, that is non-higher cost loans, loans other than real estate loans. The advertising rules and servicing rules are beyond the scope of this webinar. There's lots of materials on all of those topics, and each one of those is worthy of a lengthy webinar in its own right. Readers are encouraged to view the Consumer Financial Protection Bureau website, consumerfinance.gov, for more information on ability to repay and other compliance guidelines. There is a wealth of material on the consumerfinance.gov website to fill in some of the details of what I'm going to cover with you today. Your Christmas gift from Dodd-Frank, the Small Creditor Qualified Mortgage, the SCQM. As you'll see, this is a form of safe harbor in a sense. If you follow certain rules, you will have certain protection. And my objective today is to tell you what those rules are and encourage you to take advantage of them and make some money making residential private money mortgages. The general areas that we're going to cover today are the special rules for small creditors, and I put that in quotes because it is a defined term, making qualified mortgages, again another qualified term, or SCQMs. There's some new HUD counseling rules, both in terms of providing an advanced disclosure notice about the availability of HUD counseling, similar to what we've seen in California with the California high-cost mortgages. Some rules on when you have to get a counseling certificate from a HUD-approved counselor to actually to make a high-cost loan. There's some new point and fee caps that, when triggered, will get you into the higher priced, i.e. Section 35, or high-cost Section 32 loans. The exemptions have been tweaked a little bit in terms of what loan is not subject to these rules. And there are new ability to repay rules in effect for consumer loans secured by residential properties such as rentals. What has not changed, this is very important those of you who want to avoid consumer real estate loans. Regulation Z, with the exception of its advertising rules, only applies to consumer credit, loans for personal, family, or household purposes. Thus, business loans on owner-occupied property, homes, loans to acquire or maintain a rental real estate, and loans to bona fide business entities are and were and will be exempt. So you can breathe a deep sigh of relief from that. Section 32 is now called the high cost, and Section 35 is now called higher priced. These two types of rules only apply to consumer loans on owner-occupied dwellings. So I get a lot of questions about, does ability to repay apply to this or that? And a lot of the rules, in fact all of the rules, other than I mentioned up in the first paragraph, only apply to owner-occupied dwellings. There are some other rules that apply to consumer loans on dwellings, as opposed to owner-occupied loans on dwellings. Okay, so the higher priced rules don't apply to loans on second or vacation homes, and all the exemptions above are equally applicable. However, the new ability to repay rules do cover any consumer loan on 1 to 4 SFRs, including consumer loans on a rental. An example of that would be a client comes to you and says, I've got this rental that I've been renting out, produces great cash flow. I need to take some money out of that property to pay my income taxes, my personal income taxes. That is a consumer loan that is on non-owner occupied real property. Nonetheless, the ability to repay rules will bring that within its grasp starting in January 2014. Special treatment is given to small creditors making qualified mortgages, or SCQMs. Let's dig into that in depth now. The new regulations give special treatment to those of you who choose to be small creditors or have no other choice, and you choose to make a qualified mortgage. Now, let's go to the first part of this, small creditors. Small creditors are defined as lenders whose assets are below $2 billion. If your assets are above that, congratulations. You can probably turn this webcast off because you probably have a large legal department. Number 2, you make less than 500 first lien closed-end consumer residential loans within the preceding calendar year. Those of you who have exceeded that, congratulations as well. And number 3, you can't be a conduit to someone who is not a small creditor, such as having a forward commitment in place to resell the loan to someone who is a small creditor, or actually resell the loan to someone who's not a small creditor within defined periods of time. This would permit you to sell a loan, either have it funded by or sell it to a private investor, assuming the private investor doesn't meet 1 or 2. That is $2 billion in assets or made 500 loans in the previous year. Qualified mortgages, that's the second part of it, of the SCQM duality, are defined as 2 types of loans. 5-year, fixed rate, amortizing balloon payment loan. This product is going to be available for 2 more years until January of 2016. So that's a nice gift from Congress. And number 2, a fully amortized fixed or adjustable loan. That's applicable now and will be applicable 2016 forward. So the landscape after 2016 is going to be a fully amortized loan. And up until in the next 2 years, you can make a 5-year balloon payment loan if that's your choice, and still meet the definition of SCQM. Now, to stay within the SCQM definition, that is a small creditor making qualified mortgages, the total points and fees, and again here when we count points and fees, we're using something similar to the Section 32 test, which is essentially we only count the soft costs, such as broker commission, loan origination fee, underwriting fee, processing fee, admin fee, escrow fee, doc prep fee, those sorts of things that go into either the broker or lender's pocket, to cover overhead, as opposed to appraisal fees, recording fees, title insurance fees, those kind of what I would call hard costs. So your soft costs and fees cannot exceed 3% of the loan on loans of $100,000 or more, $3,000 itself for loans between $60,000 and $100,000, 5% on loans between $20,000 and but less than $60,000, and there are other limits for loans below $20,000, but I'm not going to discuss them here since I don't believe too many of you make small loans. Now, I mentioned protection at the beginning of this webcast. Only prime lenders are totally protected from lawsuits. What I mean by that is these prime lenders are lenders who are making loans below the higher price limits. We're talking about the Chase, Bank of America, Bank of the Internet, etc., who are making prime rate loans. And they adhere to, they have to stay below a 43% back-end debt ratio and follow the other rules. But they're making very low APR type loans, you know, looking at 4.5%, 5.5% type loans, and for prime rate borrowers. I assume most of you who are listening to this are probably not in that category, because this is the focus of this webcast is private money lending. These type of lenders who are making qualified mortgages have an absolute protection from lawsuits from borrowers based upon ability to repay. So a consumer cannot sue them and say, I didn't have the ability to repay this loan. All the lender has to do is show that they made a 5-year balloon, or excuse me, a fully amortized loan. They stay below a 43% back-end debt ratio, and that's done. They're done. They don't have to go one step further. And there was a lot of litigation over that. Borrowers claiming they didn't have the ability to repay the loan after the transaction closed, and claiming that the lender had a duty to avoid that from occurring. So that's going to be nipped in the bud, presumably under this new scheme of things that goes into effect in January. Now, those of you who are not in the prime category, the non-prime lenders, you get protection in the form of a rebuttable presumption. So if you make a higher cost, Section 35, we used to call it, or high cost, Section 32, as a small creditor making a qualified mortgage, SCQM, you get a rebuttable presumption that the borrower had the ability to repay the loan, and if there's a challenge. You're not restricted or locked into the 43% back-end debt ratio to get this protection, but you are required to consider residual income. So in a battle, if the borrower wants to challenge the ability to repay, once you show that you've satisfied the requirements for a small creditor qualified mortgage, which doesn't have a debt ratio requirement, and for the next 2 years it can be a 5-year balloon payment loan with documented and verified income and debts, the burden then shifts to the borrower to prove that the loan left them with insufficient residual income for their living expenses. So if you were in a court of law, you prove your mortgage met the SCQM standard, which isn't too difficult. The judge would then look over to the borrower and say, you guys are up. You need to prove to me that the loan left you with insufficient residual income for your living expenses. Moral of the story, and if the borrower can't prove that beyond a beyond a preponderance of the evidence, that is a 51% test, they are going to be thrown out of court. Hence, it's going to be highly important to be prepared to defend yourself by doing a residual income analysis and have the borrower certify it as accurate. So you almost are ready to once the borrower puts on a show that they did not have the ability to repay it because of insufficient residual income, you show that that was analyzed and it did leave them with sufficient residual income, and probably you're prepared to explain what they did to render themselves unable to pay their debts. Now the good news is that the government in the regulations, they don't define, in particular, what is sufficient residual income. But there is a standard and standards that have been used and for a long time in other contexts. The government has published what it believes to be, or it throws out, to be acceptable residual income for the elderly who seek reverse mortgages and veterans seeking veterans loans, VA loans. It is likely, but is not yet tested, that a court will find that if the residual income would have been sufficient for the elderly and military veterans, it would be sufficient for the average homeowner. Examples and instructions modeled after the VA and FHA guidelines are included with this outline. So VA loans have been made with this residual income test for a very, very long time. The other things that is considered in a VA loan is stability of income and credit score. So you might want to model your lending program to almost mirror the VA lending guidelines, and say, Judge, this is what's done every day for our military veterans, and we follow the VA guidelines. This webinar will assume that you are a small creditor making a qualified mortgage, or SCQM, if that's not obvious already. What is residual income? Okay. Residual income is the borrower's verified income, and all these you've got to document and verify from third-party sources such as an employer, income tax returns, bank statements. Third party, you can't just take the borrower's statement. You must verify income. Residual income is verified income after payment of all housing expense, all taxes, including income taxes, utilities and maintenance, and installment debt. And the VA guidelines on utilities and maintenance do give you a lodestar or formula of 14 cents per square foot for utilities and maintenance on a United States residence. Residual income is computed by subtracting all of the above from gross income. So it's kind of what's left over after paying all debts and utilities and maintenance and income taxes. The focus is less on the debt ratio and more on residual income because the Small Creditor Qualified Mortgage rules has no debt-to-income cap or standard, like the prime lenders have to live by the 43% cap. Now, the FHA and VA consider the following residual income to be sufficient in the Western United States. They do have charts for the East and the various other areas of the United States, but I'm going to assume most of my listeners are in the West. But so looking at this, you'll see that on a family size of one person in the house, that if their back-end debt ratio is 41% or less, all they need is $589 in residual income. If it's over 41%, the VA guidelines require you to enlarge this up by 20%, and I've done that for you on this table. So take the number here in the middle column and multiply it by 1.2 to get the number to the right column. So the VA guidelines do allow a back-end debt ratio of more than 41%, but they do require you to then add an extra 20% to the family side, to the residual income number. Family size of 2, 886, under 41%, 1063, over 41%, etc. And you can read the rest. Higher priced small creditor qualified mortgages, Section 35 loans. Here's what we're going to talk about now. The previous, what used to be called subprime loans, are now, and we used to call them Section 35 loans. They were in that gap between the prime loans at very low APRs and the Section 32 loans, the high-cost loans we used to call them, that were, in the close to the double-digit APRs. So that gap in between now, the subprime gap, is now called the higher-priced. So I will continue to refer to them as Section 35 or higher-priced throughout this webcast. Now, again, these rules apply to single-family principal, i.e. owner-occupied residences. And these rules cover HELOCs now, home equity loans, the cash-out loans, purchase loans, and home improvement loans. So Section 35, the higher price rules will apply to all of that type of product. What it won't apply to is business credit, and many of you have heard me talk about business credit. The majority of the proceeds of the loan will finance an active business enterprise versus passive investment, something that, so we're looking for active business. The driving motivation is to finance that business, and those are the two things I look at when I evaluate whether or not a loan is true business credit. Loans to buy or maintain a single-family rental are exempt as a business loan. Business purpose loans secured by principal residence are exempt. A person takes equity out of their home to start a dry cleaning business, that is exempt. That is a business loan. Loans to non-hobbyist flippers are exempt. Let me expand on that a little bit. Normally, the people who buy fix and flip properties do so with some regularity, and their activity rises to the level of a business enterprise or a business occupation. However, if there's a doctor or a dentist or candlestick maker who wants to buy a little house and fix it up and sell it on a part-time basis and does like one a year, you have to worry about whether that, I call that person a hobbyist flipper. And that is a gray area between a business and a consumer purpose. So it's sort of a hobby to fix up a house and sell it. You have to really watch out for that type of non-professional flipper. New manufactured housing is exempt. Entity credit, such as loans to bona fide, not recently put together just to try to get around the rules type entities. LLCs, LPs, corporations, bankruptcy trustees are exempt credit. However, trusts should be treated, living trusts should be treated as consumers. Ignore the living trust, not as entities. And loans on more than 4 units are categorically excluded as business credit. True bridge loans of 12 months or less for the purpose of financing a new principal dwelling are exempt from the Section 35 rules, but because those loans are usually short, they could be subject to the high cost, Section 32, if the points and fees or other terms get into that category. We're going to cover Section 32 in a moment. So if you could make a 9% 1-year APR bridge loan and not have to follow these rules, but it has to be a true bridge loan. Reverse mortgages, initial construction loans, there are special rules for construction takeout combination loans. Now, thresholds for higher priced. So everything below what we're going to cover right here, is conforming. I call that the prime product. So if a loan exceeds these prime product parameters, then it's going to be a higher priced mortgage. So on a conforming basis, if the mortgage loan, on a first mortgage, if the APR is more than 1.5% over the Freddie Mac average prime rate offer, APOR, I'll call it from now on, for comparable loans, then it could be or will be a higher priced mortgage. You can get the APOR rates at the website that you can see right here in front of you. If it's a jumbo loan, and the APR is more than 2.5% over the APOR, then it will be a higher priced mortgage. Junior lien, more than 3.5% over APOR, and you have to stay, of course, within the point and fee caps I mentioned above, the 3%, the 3,000, etc., to keep your qualified mortgage status. So it doesn't take much to get you into the higher priced or Section 35 category. Now, on a mechanical basis, I'm going to just briefly review the rules about timing of disclosures. A written application means the submission of financial information in anticipation of a credit decision. It's received when it reaches the lender's offices directly or through a broker. The definition of written application has been changed very, very slightly. I don't think it's material. You know when you have an application when the borrower is seeking some response from you other than an inquiry or a pre-qual or something like that. A business day is every day the lender's offices are open, counting the day of mailing as day one. No disclosures are required if the application is denied or withdrawn within the business day period. However, you probably owe them a credit denial notice. There is a new appraisal disclosure notice that has to be sent with the earlier disclosures. It says, we may order an appraisal to determine the property's value and charge you for this appraisal. We will give you a copy of any appraisal, even if your loan does not close. You can pay for an additional appraisal for your own use at your own cost. I don't know why anybody would do that, but if you're curious, you can get your own. And then a copy of this of the appraisal must be given to the consumer at least 3 business days before closing. And if the loan is not made for any reason, it must be mailed to the homeowner within 30 days So there's going to be a new appraisal disclosure as part of the doc set now. The TIL appraisal disclosure and either an itemization of amount financed or good faith estimate and a mortgage loan disclosure statement by real estate brokers must be mailed or delivered. However, only the MLDS must be signed by both borrower and broker. The information in in all these disclosures must be based upon the best information reasonably available. Early disclosures must contain this statement. You're not required to complete this agreement merely because you have received these disclosures or signed a loan application. The typical disclosures that are sent, and I will provide you with a list shortly: privacy policy, state and federal non-discrimination notices, notice of right to receive a copy of the appraisal disclosure, FICO score notice if you're pulling credit, credit authorization for signature and return. Be prepared to prove delivery. Use cover letter with a list, a checklist. Dear borrower, enclosed are the following. Send by certified mail, overnight courier. You can fax, but always make sure, email, make sure you get an acknowledgement by the borrower that they received it, were able to open it, and have that acknowledgement in writing. The use of estimates and ranges is encouraged. One thing I haven't mentioned is e-signing. To my knowledge, all of these except the MLDS can be sent by e-signature, such as DocuSign. I've heard rumors that not rumors, I've seen actual text from one of the BRE newsletters that they do not allow you to DocuSign an MLDS. Not quite sure why they take that position. It's pretty archaic, but there you are. There's now a new counseling notice that must be given to borrowers at the first stage of the application process. And I'll read it to you. If you would like counseling or assistance, you can contact the following: U.S. Department of Housing and Urban Development. For a list of home ownership counselors or counseling organizations in your area, go to, and there's a website, or call 800 number. The rules do require that you provide a list of homeownership counselors or counseling organizations, so I added to this CAN disclosure from the government. The following is a list of the homeownership counselors or counseling organizations in your area. And you can compile that list by going to the HUD website that I show you on this page. And there are, in my county, Orange County, there are several, like 3 or 4. A counseling certificate, what is that? Well, that is a piece of paper signed by one of these HUD-approved counselors that to the extent that they have received the loan documents, they have discussed the loan documents with the borrower. That's the two things that are required for a certificate. It's not required to close a higher cost, a Section 35 loan, but it is required for a high cost or Section 32 loan. Borrower, or either you or the borrower can pay the counseling fee. There's no rules on that. And you can't steer them to a particular counselor or to someone that's affiliated with your company, which I think is probably pretty rare. So here's your early disclosure list. You've got your MLDS, TIL, good GFE, notice of right to receive copy of appraisal, and there's new appraisal disclosure, state and federal fair lending notices, FICO notice, the new the HUD counseling notice with a list of local counselors. We typically include a corporate privacy policy. Now, after you send that early disclosure package, the borrower cannot sign contracts or incur any fee except a credit or appraisal fee until 7 business days have passed after the early disclosures. Business day is the same as for rescission, every day except Sunday and federal holidays, so it works out to be about 10 days. However, you can count the day of mailing as day number 1. It still works out to about 10 days. There might be situations where something has changed after the initial disclosures are given. If the APR will be higher by more than 1/8 of 1%, redisclosure is required. You can ignore inaccuracy as a result of estimates or items that were stated as ranges, as long as they're within the estimate or range. If you do have to redisclose because there's an inaccuracy, there's a 3 business day cooling off period after redisclosure before you can go to docs. And then there's some rules that I give you here on what days to count and not count. The 3 and 7 day waiting periods can be waived by a written waiver that cites a bona fide personal financial emergency, such as imminent foreclosure, that will occur during waiting periods. Okay, if the loan is a higher price qualified mortgage, and a higher price SCQM, the following rules apply. There must be impounds on first mortgages, except co-ops, loans on co-ops, which they collect their taxes from the HOA dues. Initial construction, bridge loans, or reverse mortgages are exempt. Ability to repay. The consumer must have the ability to repay, and there are new rules for determining that ability. I've sent you the ability to repay guidelines. One important change is that the ability to repay the balloon payment, if you're going to do a 5-year balloon product, does not have to be considered. In other words, you don't have to analyze the borrower's ability to repay the balloon. That was a point of controversy prior to this change. No fixed percentages are applicable in terms of debt-to-income ratio, back-end debt ratio, but residual income is the key to sustain a finding of ability to repay. And again, as I mentioned earlier, borrower has the burden of proving that the loan left him or her with insufficient residual income. Loan rule number 3. Payments must be based on an amortization not exceeding 30 years, but you can have a balloon payment in 5 years until January 2016. Fixed rates. ARMs are permitted only if the loan term is more than 5 years and fully amortized over the term of the loan. Mandatory arbitration clauses are out the window. And this is very important. Your NMLS ID and the name of the person with primary responsibility for origination must be in the application, note, and deed of trust. So, for all to see. The cannot charge for payoff statements, and there's time limits on how fast those have to be produced, 7 business days. There are your charges are allowed if it's sent by fax or courier at the borrower's request. Prepays are pretty much gone. Rolling lates are gone. You must stay within the point and fee caps I covered above to stay within the qualified mortgage status. And a counseling certificate is not required for a higher cost loan, only high cost or Section 32 loans. Now, let's take a look at this form. This is the Veterans Administration form, and let's see if I can blow up this thing a little bit so we can go over it. Now, this is a VA loan analysis that I've done for you. We have our borrower, and then what we're trying to determine here is debt ratio as well as residual income. Very, very critical. We've given our early disclosures. Now we need to make a decision whether or not this borrower has sufficient debt ratio and residual income to qualify for a higher priced or even a high cost mortgage. So our borrower, John Doe, is a 32-year-old consultant. He's seeking $125,000. He's got $5 grand in the bank. His current housing expense is $1,500. He's single, but he has 2 children, must be divorced. Our loan term is 5 years. We're going to do a balloon payment loan. We're going to do a 9%, 30 due in 5. So his monthly payment is going to be $1,006. Real estate taxes, I took at 1.2%. You can do the actual numbers off the prelim. Hazard insurance, $600 a year. It's about a $200,000 house. Special assessments, 0. Maintenance and utilities, I tack those on. It's a 2,000 square foot house. 14 cents a foot would give me $280. And he's got some HOA dues of $140. He's got on the installment debt side, he's got a car payment, he's got a credit card, and he owes some student debt to Sallie Mae. So his total debts are, on the housing expense side, $1,676. Installment debt side, $700,000. Now, we then have to, hopefully this works, yeah. We now are going to look at his take-home pay, so to speak, and residual income. I figured his tax burden was about 30%. He's got some itemized deductions for his mortgage interest. He's got some property taxes. He's got a couple of dependents. Those are all good things if you're trying to avoid taxes. And so I computed either you can use tax tables, you can use his actual tax return, you can use whatever is a good and stable, reliable source for his income taxes. And I put in some figures here and figured his total tax burden was about 30% of his paycheck goes to the government. So that gives his tax burden at $1,625. So out of his gross income, he makes $65,000 a year. That's $54.16 a month. I took away his taxes, which means his net take-home pay is $3,791. I then went down to line 40 here, and from that I deducted his installment debt, got to pay his bills, leaving his total net effective income at $3,091. Then I took away his housing expense. Up here we computed at $1,676, and lo and behold, his balance available for family support, i.e. residual income, was $1,415. The guideline, if you recall, is $1,112. And I used the higher figure because I computed his debt ratio in section 44 to be 43.87%. So he's over the 41%, so we've got to use a little higher number, 20% over the base guideline, which means that he qualifies if his income, his residual income exceeds $1,112. Well, he's well over that. So he's good. Now remember, here's the table of what the VA considers to be acceptable. Final docs. Here's a list of your final docs. Note, don't forget the promissory note. Don't forget to include your NMLS number, name and number of the name and NMLS number of the loan originator, the individual loan officer. Deed of trust, same caveats. Truth of lending disclosure. Each borrower gets 1 copy. Mortgage loan disclosure statement. Make sure you get it signed if you didn't get it signed before, or if there's been changes, get it signed again. Good faith estimate. 3-day right to cancel. Each borrower gets 2 copies. Payoff approval if it's a refi and you're paying off an existing loan or paying off other debts. Make sure you get that approved. Residual income analysis and approval. We're going to cover that a little bit more. Escrow instructions, estimated HUD 1. Now, let's go to the next level up. We looked at prime a little bit, at least what was what you would do to get over prime. Now, then we talked about the middle level, the subprime or higher priced mortgage. Now let's talk about the high cost, Section 32. Now you got to remember, all of the rules that I covered that apply to higher priced or Section 35 loans equally apply to higher cost loans or high priced loans. Okay, now the test here are a little bit more complicated. Okay, again, Section 32 and high cost loans only apply to owner occupied principal dwellings. where the APR at consummation will exceed 6.5% over the APOR, 8.5% as to junior liens, as of the date the interest rate is set, or soft costs and fees will exceed 5% of the total loan amount, or there is a prepayment penalty, because that would be a no-no in any event. Other limits apply to loans under $20,000, which I'm not going to bore you with. All broker compensation paid directly or indirectly by a consumer must be included in the computations. However, loan officer compensation paid by a mortgage broker to his employee does not have to be counted a second time, assuming, as it should, that it's already in the computations in APR. Loans excluded from additional requirements. Of course, this is very similar to the list I covered earlier. Business credit, even if secured by a dwelling. Non-owner occupied, such as rental properties, second homes. But the ability to repay rules and the disclosure requirements of a TIL, GFE, and NMLS all apply to any consumer loan secured by a 1 to 4 SFR. That is the consumer loan on the rental example I gave you earlier. Whether or not the borrower occupies it full-time or part-time, it's irrelevant. If it's two things collide, that is consumer and 1 to 4, then the ability to repay is going to apply unless it's exempt as business credit for some other reason. Entity credit, covered that before. Initial construction loans. You got to watch out here though, because we also have some California rules on high-cost mortgages. So, and those apply to any loan that's under the Fannie Mae county-specific conforming loan limit. And under those rules, only construction loans of 1 year or less are exempt from the California high-cost rules. So watch out for that. Reverse mortgages are exempt, and loans on more than 4 units as business loans. HELOCs and loans to purchase a home are no longer exempt from Section 32. Now here's your early disclosure list, very similar to what we had for Section 35. Let's see, the two that are different are number 9 and number 10. The HOPA notice, you must get a signed receipt for the HOPA notice. This is the notice, if you recall, it says you are entering into, you could lose your home and all the equity into it. And then there's a California counterpart to that, called the California Consumer Counseling Notice, that must be given as well. Okay, if the loan is up into the high-priced Section 32 limits, all of the rules and timing above apply that apply to higher-priced Section 35 loans. So you must document and verify ability to repay. Prepays are gone. Impounds on first lien, and the timing rules apply to the early disclosures. Now here are some substantive rules. No balloons sooner than 5 years, which you would have to comply with in order to be a small creditor qualified mortgage. No more than 2 prepaid payments. That was always a Section 32 rule. No default interest. And I note that's probably not enforceable anyway, so you're not losing anything there. Number K, you must obtain a consumer counseling certificate from an approved HUD-approved agency before you can close that transaction. Late charges are limited to 4% of the payment. No rolling lates. No balloons sooner than 5 years. That should have been a separate one. Actually, it's a duplicate. Cannot finance into the loan any soft fees. This is a big one that makes a biggest difference between the two Section 35 and Section 32. You cannot build into the loan or finance by the loan itself the soft cost, such as commission, loan origination, doc prep, escrow, underwriting. They can finance the hard cost, title, recording, things of that kind, appraisal. No fees for modifications or extensions. No fees for payoff statements unless it's faxed or couriered at their request. Final docs. Don't forget this is very similar. Let's see what else is new here. Yes, the residual income analysis and approval is the same. Right to cancel. Essentially the same as Section 35. Sweet spot loan products. Let's talk. Where does all this leave us? There's a couple of products I'm just going to kind of cover with you briefly, kind of summations of what I think will be the loan product of the future. Both of them require that you consider the borrower's ability to repay, but you do get a presumption of ability to repay that requires the borrower to prove they had insufficient residual income. You anticipate that defense by building a strong residual income analysis and getting the borrower to approve it. Now, owner-occupied 5-year fixed-rate balloon loans, first trust deed until January 2016. This is the first product I think that's out there. APR just under the Section 32 high-cost limit. As of December 9, the maximum APR on this 5-year loan would be 9.65%. So we're staying under the Section 32 limit at 9.65%. Fixed rate, 30 due in 5 on the amortization. It passes the FHA VA residual income test. And in your program materials, I actually take and filled out a residual income test analysis for you to show you how I did it when I made those computations. Counted points and fees are under the 3% $3,000 limit. That's a very typical, I think, private money product. Now, you could take this same one, and if you wanted to go Section 32, same rules would apply, except you're not going to be able to finance points and fees, soft costs. But other than that, you could do it. And, you'd have some late charge limits, 4%, but otherwise it's not really that much different. You still get the presumption of ability to repay if you follow the other rules. So the other one that's going to be with us, that's not going to be limited to 2016 is just a fully amortized product, 30-year probably, or 15-year fully amortized loan. Probably, given that it's a longer-term loan, you pick up a higher rate. You can go up to 10.33. If you're going to do an adjustable, the first 5 years should be fixed. 30-year fully amortized, passes the FHA VA residual income test, and counted points and fees under the 3% limit. So not a hot shot. Now, if you want to go Section 32, then you would add to this list, the unfinanceability of the soft costs and the 4% late charge limitation. You see, that's not so scary. Those of you who have relied upon the exemptions, the world hasn't changed for you. Those of you who want to start doing some consumer owner-occupied lending, the world's changed in your favor. Don't be afraid of them. To summarize where we're at, today you can make a consumer owner-occupied loan of 2 types. 5-year balloon payment loan, the 15-year or 30-year fully amortized loan, no problem. You have to limit your points and fees, the soft points and fees, to 3% of the loan amount, no problem. And you can either go Section 35, which is the higher priced, or you can go Section 32, the high cost, no problem. You have to document and verify ability to repay. You've got to gather income documentation. It's got to be verified by a third-party source. And you have to do a residual income analysis. And I believe if you stay within the VA guidelines and the FHA guidelines as to residual income, you're going to be okay. A court's going to say if it's good enough for a veteran, then it's going to be good enough for the average homeowner. So it's not something you should be afraid of today, and I think you should take a quick look at it and stop listening to all the fear and trepidation out there in the market. In the right circumstance, it can be a very good product. Well, thank you for listening to my presentation. I'm always here to be able to help you on this or any other compliance topic. I really wish you a good day and happy lending. Take care. Bye-bye.